All right, so let's talk landlord-tenant. This is a really interesting area of law, primarily covered by common law and contract law. And in California, we also have some statutory law that influences landlord-tenant, and I'll talk about that as part of this lecture. Let's dive into the leasehold estate. And the leasehold estate is basically the tenant's right to occupy and use a property for a specific period as defined by the lease agreement. The lease agreement is the contract. It grants possession, but not ownership of the property. And I always tell people to think about as a landlord or a tenant, when you are a tenant and you are living and you have a lease, you basically have the right to live on that property in accordance with the lease, but you have the exclusive use of the property. The parties involved in a leasehold estate are the lessor or the landlord and the lessee, who is the tenant, the person that's renting the property. So some types of leasehold estates, the fixed term tenancy, which is a lease for a fixed definite period of time, such as 1 year, 6 months, or even a specified number of days, 30 days. Start and end dates are generally clearly defined in the lease, and then it automatically ends when the term expires without requiring notice from either party. Many leasehold estates for term expire into a month-to-month tenancy. That's fairly common, especially in California. And so a tenant signs a lease for an apartment for 1 year. And so they have that apartment for a year, and then after the year, it would be up to the tenant and the landlord to get together to determine if they whether or not they wanted to continue that relationship or go their separate ways. A periodic tenancy is a tenancy that automatically renews for successive periods, so month to month or year to year, or until either party provides notice of termination. So a periodic tenancy, most common in California, is going to be the month-to-month tenancy. There's no fixed end date, and so the tenancy continues indefinitely as long as the rent is paid on time and on a consistent basis. Either party can terminate the lease with proper notice. Generally, it's 30 days. So a tenant who rents a month on a month-to-month basis would be an example of a periodic tenancy. Tenancy is at will is a lease that can be terminated at either time by either the tenant or the landlord without a specific duration. So there's no fixed term. The tenancy continues as long as both parties agree that they want it to continue. It can terminate at any time. Typically, you want to give reasonable notice, but a tenant who rents a property without a lease agreement and both parties agree that either can end the tenancy at any time would be a tenancy at will. And then we have a tenancy at sufferance, which is when a tenant remains in possession of the property after the lease is expired and without the landlord's permission. And this continues until the landlord can take legal action to evict the tenant or accepts rent for another term. So the tenant's lease ends, but they remain in the apartment without the landlord's consent and no new lease is signed, would be a tenancy at sufferance. So how are leases created? Leases can be created orally unless the term of the lease exceeds the period specified by the statute of frauds. In most states, that period is 1 year, and any oral lease for a period longer than the statutory period is invalid. So typically, a lease for less than a year can be created through an oral lease. Something longer than a year typically needs to be written by virtue of the statute of frauds. A lease required under the statute of frauds has to contain the identification of the parties. It has to identify the premises where it is, specify the duration of the lease, either 1 year, 6 months, month to month, whatever it might be, state the rent that has to be paid, and has to be signed by the party against whom enforcement is sought, typically the party to be charged. Ideally, with a written lease, you want a signature from both the landlord and the tenant. So what are the duties of the landlord? Well, first of all, the landlord's primary duty is to deliver possession of the property. On day one, the property is supposed to be ready and available for the tenant to move in. So that's delivering possession. The landlord also has a responsibility to ensure that the apartment or the place that's being rented is habitable via the warranty of habitability. And basically what the warranty of habitability says is that everything needs to be in good repair, there are no safety issues. The place has to be habitable for humans. So for example, a broken toilet is a habitability issue if you can't use your toilet. Broken air conditioning, at least in Southern California, is not an issue of habitability. So there are certain issues that are habitability issues. Toxic mold would be a habitability issue. Heat or electricity or gas, whatever the power is, would be a habitability issue. A gas leak would be a habitability issue. Things that are minor in nature, like I said, air conditioning that's not working right, again, in California, is not a habitability issue. The landlord also has a responsibility not to interfere with the tenant's quiet enjoyment of the unit. The tenant has the right, because they are renting the unit, to live their lives in the unit without the landlord constantly sticking their nose in, trying to figure out what the tenant's doing or interfering with their general quiet enjoyment of the unit. The rights of the landlord, the primary right of the landlord is to receive rent as agreed to in the lease. And the landlord has the right to access the property for repairs, inspections, and maintenance, typically with advance notice. In California, that is 24 hours notice for repairs and things like that. Or if there is an emergency, they can enter on emergency. What are the rights of the tenants? Well, the tenant has the exclusive right to use and possess the property for the lease term. And they have the right to what's called quiet enjoyment. Quiet enjoyment basically means that the tenant is entitled to peace and quiet, free from interference by the landlord, and technically also neighbors. So if you have a neighbor that is constantly, they have a barking dog, that's a quiet enjoyment issue. And so if you complain to the landlord that the neighbor's dog is barking, and this assumes that the neighbor is also a tenant of the landlord has a responsibility to do something about that quiet enjoyment issue. If the barking dog is a neighbor that is not managed by the landlord, like it's in the house next door, that also may be a quiet enjoyment issue, but it's a nuisance issue with the city rather than a quiet enjoyment issue with the landlord. So what are the duties of the tenant? The tenant's primary duty is to pay rent on time in the agreed upon amount that is stated in the lease. The tenant also, upon departure, has a duty to restore the property to their original condition. If the tenant has put up paintings or put up art on the walls, the tenant has a responsibility to cover over the holes that were used to hold up the art. The tenant has the duty to use the property for lawful purposes only and to give notice upon termination of the lease term and whatever that is in accordance with the lease, typically 30-day notice. If there is an issue that the tenant is having that the landlord is not necessarily paying attention to, or the landlord has agreed to pay attention to it, and there's been an agreement upon how the tenant will address the issue. The tenant may have the right to repair something that's broken and deduct that amount from the rent. Typically, things like that are stated in the lease. Sometimes landlords don't want you to do that, so you should always check with your landlord. Broken toilet, for example. Sometimes landlords want to take care of that themselves. Other times they'll say, okay, go ahead and take care of it and deduct it from the lease. If there is an issue that causes you to abandon the property for a set amount of time or for the duration of the lease, if it's a habitability issue and you can't stay there, then you have the right to leave, and your landlord has the responsibility to reimburse you for the time that you are away. In some cases, tenants can withhold rent if there is an issue that the landlord is not addressing that needs to be addressed. Again, it generally needs to be a habitability issue or an issue that is specified in the lease. So I talked about the air conditioning. If the lease specifies that the unit has air conditioning, that is the fact that the air conditioning is broken is a violation of that contract. And so for that, a tenant could withhold rent. And tenants can file lawsuits for damages against their landlords. So landlord remedies when tenants breach. The first would be an eviction. In California, it's known as an unlawful detainer. With an unlawful detainer, it's not as easy as it sounds. It actually takes about 6 months to get somebody out. So not as easy as it sounds, and is generally relatively expensive. So landlords generally will try to avoid that if they can. For tenants that do leave and they have not kept their end of the bargain in terms of restoring the property back to its original condition, the landlord has the right to withhold the security deposit, but they have to provide receipts for what the security deposit was used for. A landlord has 21 days in California to return your security deposit with receipts and with an itemized list of what they spent your security deposit on to fix. Landlords also have the right to sue for damages. However, there is in California the duty to mitigate, which means that landlords have to try to minimize losses when necessary. And so if a tenant breaches the lease, so if a tenant needs to move out early, for example, the landlord has a responsibility to mitigate that damage by advertising the apartment and getting it rented as soon as possible. In California, we have a special piece of legislation, which is referred to the Tenant Protection Act of 2019. It began January 1st of 2020, but was retroactive to March 15th of 2019 to prohibit landlords from making anticipatory changes in terms of rent, living conditions, things like that. So in California, the max increase in rent from year to year is 5% plus the local inflation rate. So in most cases, that's about 2 to 2.5%. It's been more lately, but generally the max increase is about 7 to 9% that your rent can be raised on a yearly basis. It is designed to protect against extreme rent increases. There are some exceptions. Condos and single-family homes, landlords can raise those rents to whatever they want. Duplexes, where the landlord lives on the premises, those are also excluded, and properties that are less than 10 years old. Some additional protections from the Tenant Protection Act, or the TPA. Landlords have to show just cause when evicting a tenant, meaning that a landlord just can't simply end the tenancy because they feel like it. There has to be a reason why they're asking the tenant to move. Landlords have to show just cause when evicting a tenant, which means that the tenant has to be in violation of the lease somewhere. So for example, my lease says no pets. If I have a tenant who I come home and I see that they've brought home an adorable puppy from the Humane Society, I can't tell that tenant that they have to move. What I can say is you're in violation of the lease. If you don't get rid of that adorable puppy, you will have to move. And so the tenant has the right to cure that violation. Landlords who want to substantially remodel or convert units to condos have the right to evict their tenants or end their tenancies, but they have to pay the tenant the equivalent of 1 month's rent. So it's relocation assistance for tenants, for landlords who are, again, moving folks out. Basically, the only reason you can move folks out is for substantial remodels, convert units to condos, or to move a family member into the unit, and the family member has to stay there for, I think it's 1 year or 2 years, or the tenant has legal recourse against the landlord. Again, rental assistance is required for landlords who move a tenant out to move a family member in, equivalent to 1 month's rent. So that's the end of the lecture. Landlord-tenant law, super important because at some point we're all going to be tenants or landlords. Hopefully this gives you kind of a framework within in which you can understand that relationship with your landlord or your tenant.